near, seek attention, and you shall be heard. God save the United States of Great Britain, Lord, and His honorable court.
Please be seated. We have 4 cases on the docket this morning. We're going to take them in the order that they appear. After the first case, we're going to take a 15-minute break for coffee in the Commons, and we ask everyone to join us for coffee after the first case. I'll make a general announcement. If you are the appellant on a particular case and you want rebuttal time, let me know, and I'll try to remind you, but ultimately you're going to be responsible because you do have the clock there. So if I forget, you're on your own. Okay. Are parties ready on the first case?
Yes, sir.
You may proceed.
Good morning, Your Honor. May it please the Court, Francis Squash, Chris Bello at counsel table, and Lynn Washington on behalf of the appellants, Urban League of Greater Miami, and construction managers doing business as Construct 2. Your Honors, the issue before the Court is an appeal from a final agency order that dismissed a formal written protest of a bid. The agency adopted the recommendations of the administrative law judge, which relinquished jurisdiction, and the agency found that Urban League and Construct 2 did not have standing to bring their written formal protest. The issue before the Court is whether the agency and the LLJ erred when it found and applied the standing incorrectly, applied the law incorrectly with regard to standing. The Administrative Procedure Act, Section 120.57, the petition was filed by Urban League and by Construct 2 as individuals, and that petition was filed pursuant to 120.57. Specifically, Your Honors, 120.57 sub 3, which provides that standing is conferred on any person who is adversely affected by the agency action. This is a question of law before the Court, and the test to be applied is the test of substantial interest, which is injury in fact and the type of injury that the statute's intended to protect.
Wasn't the focus here rather than standing in the administrative proceeding, whether these people were actually qualified to submit the bid? I mean, isn't that the real issue here? It's not administrative standing.
I would disagree, Your Honor. And the way they got to standing was to argue that we were non-responsive. However, under the law, standing can be established even by a non-bidder. And that's the Center for Advocacy case that's cited in our brief and also citing Fairbanks. Therefore, even a non-bidder or an unqualified bidder in this case, which is what the judge found on non-evidentiary evidence, on a side note, Your Honor, and that's
how do you establish an injury? If you're an unqualified bidder and cannot get the project, how do you establish an injury? Because
an injury is established, Your Honor, if you have a potential stake in the outcome of the agency action, which in this case, both Urban League and Construction 2 had.
What is their stake if they can't get the contract?
Well, their stake is the fact that they don't even get to protest, whether the merits, that goes to the merits, whether the evaluation was fair, the ranking. And I think you have to step back one point.
Well, no. If they are not a qualified person and they can't get the contract, what stake do they have in this proceeding?
Well, that's the point, Your Honor. They do have a stake in the proceeding because they are qualified under the law. Under the law, under 489.128, construction managers had a contractor's license. They were a JC. They could proceed. That's another error that the Court committed. I mean, even though he did find...
the proposal was submitted under the name of Strikeforce.
No, the proposal was submitted, Your Honor, under 2 individual names. The name Strike Team was used to refer to an entity of more than 10 individuals, just like every other team did the same thing. If you look at the rankings on page 27, you'll even see when we were ranked as Construction 2, because the proposal as well as the protests were filed by 2 individual entities. Strike Team was a label used to refer to the entire team. This wasn't just a construction contract. It was a financing. It was a design. It was a renovation and a construction. So there were many disciplines that were brought in. Every other responder, and that was admitted at the hearing, also had a team approach. And that's why they call themselves the Strike Team. That was a nomenclature used in order for the proposal to refer to everyone. But actually, the bid, the proposal, Your Honor, was filed by 2 individuals, 2 entities.
Did the Strike Team have legal status, though?
Excuse me, Your Honor?
Did the Strike Team have any legal status?
Well, the Strike Team wasn't the party. The Urban League and Construct 2 were the parties. They were the ones that individually, both of them have standing. Construction team obviously has standing because they were qualified legally. But we would submit, Your Honor, even if you find that they're not responsive, which is what the administrative law judge held, under the case law, you would still have a standing because you have a potential stake. In Fairbanks, it wasn't even a bidder. So you don't even have a bidder who was given standing. In Fairbanks, it was just a vendor who was going to supply the manufacturing to the potential bidder. And the court said
Yeah, but
all
they had
that.
an economic stake in that.
So does, well, I was going to say Strike Team. So does Urban League and Construct 2. They have an economic stake in getting this bid. And if in fact we reach the merits, we will be able to show in our allegations that the evaluation was unfair and we should have been ranked number 1 bidder instead of the number 5 bidder. So they did have their injury. In fact, was not being able to bid for this contract when in fact they had the qualifications. As I stated before, even if you find that it was unresponsive, which we don't concede. We think, Your Honor, that the fact that construction managers had their JC is sufficient for them to proceed on the protest. All that we're asking is to proceed on the merits, to determine whether, in fact, the evaluation was fair and in consideration, and that's what's alleged in the petition. And the protest, again, was filed by 2 individual entities, not by Strike Team. Strike Team doesn't exist. The university argued that. There is no entity called Strike Team, just as there is no joint venture. That was never, that is a legal entity. There is no joint venture. There is just these 2 individual entities who filed their proposal, were ranked, were found to be responsive. And it's important to note that in the proposal,
You know, I find something interesting, and correct me if I'm wrong.
Mm-hmm.
You mentioned the Fairbanks case.
Yes, Your Honor.
That didn't, name Fairbanks didn't strike me.
It's cited in...
your cited cases, in your brief, in your reply brief. Did you cite that case in your brief?
No, it's cited in Center Advocacy, Your Honor. It's quoted in the case Center Advocacy versus DCF that I cited in my initial brief. It refers to it. So if you refer to Center Advocacy, where they set out when non-bidders can have standing, and it is cited there, and it has an explanation of the case in Fairbanks.
So you do not concede that Urban League lacks standing?
No, Urban League does not lack standing, Your Honor. They have a potential stake in the outcome. As a developer of this project, they have a potential
They did
stake.
not hold a contractor's license, right?
But excuse me, Your Honor, that's not required. All that you have to have is one party. Under 489.128, if you have a GC on your team that has a license, then they can do the
But
construction.
I understand that to be a requirement of the aspect of forming a joint entity. You can, under the statute, you can perform as a joint entity with one party having the license. But the university's argument and the judge's findings were that your clients did not form that joint entity pursuant to the requirements of that statute.
And our position is, Your Honor, that they didn't have to form a joint entity and have one separate license. Our position is that one party or one individual had construction managers or construction 2 had the GC license. So therefore, it allowed them to proceed. Because this is a multidiscipline type of project, Urban League doesn't have to have the GC. It's just like most of the teams that submitted and were ranked is the same style. All of the teams had architecture, contractors.
I assume all the other teams had joint entity status or some other legal entity status.
No, I believe that the evidence was that they submitted, I think Premier, which is the intervener, submitted individually as a sole signatory under the IT, but they had a team under them that had several entities.
But I mean,
Go ahead.
But I mean, an entity like Premier or any other construction company can retain experts and consultants to assist it, but the bid and the proposal are by Premier. They're solely responsible. That's the legal entity that makes the argument for, winning the bid. Here, you didn't have that, is my understanding. You didn't have Construct 2 saying, we are bidding for this program, and I mean for this award, and by the way, we have these other entities to help us.
That is in the proposal. The proposal, first of all, was for financing and design and renovation and construction. So you had to have different licenses. You had to have somebody to have the financing, because there was a clause in the proposal that ownership of the actual housing may have been transferred to the award, the entity that won the award. However, Construction 2 as an entity had standing to proceed. Urban League as an entity has a potential stake in the outcome. Whether they were qualified, yes, the proposal required this team. It didn't require just a construction
So is it
company.
your argument that your status, in essence, is not significantly different than Premier or any of the other parties?
Correct, Your Honor. I think that what happened was when the university started referring to us as the strike team, it sort of, the judge sort of lost his way and started focusing on whether the strike team was a legal entity and whether these two people were joined as one legal
You
entity.
refer to yourself as the strike team, right?
Well, in the proposal, yes, we do refer, but that's not just two entities. That was like 10 individuals, architect, banking, everything that was needed for this project. And I think that this wasn't a construction project. This was a finance, renovation.
But who is the entity that would have been responsible if Florida A&M accepted the bid? And who would have been the entity responsible that Florida A&M could have held legally responsible?
It would be the two signatories to the proposal, which would be Urban League of Greater Miami and Construction 2. Construction 2 being the JC and Urban League being the developer. And under them, they had a team. But the ones who signed the proposal and who were going to be, and as well as the protest, were these two individual
Didn't
entities.
your proposal, though, talk about a joint venture?
And
And the reason I'm saying that is I go to the Florida Administrative Code talking about the responsibilities of when a joint venture could bid on a project such as this.
The proposal,
And it appears that prior to doing it, you have to have a joint venture agreement prior to the bid being submitted. Copies of the joint venture agreement and statement of authority must be received and approved by the board office prior to the time of the bid. I'm reading 61G 4-15.0022.
yes, Your Honor. First of all, to answer your first question, in the proposal, if you read the entire proposal, we refer to ourselves as qualified Florida contractors and that the project manager would be construction managers on the construction if you read the entire proposal submitted. There are points where they refer to the strike team as the project leader, but that was the whole team. The construction would be handled by construction manager. As far as the administrative rule that you just cited, we would submit, yes, if we were a joint venture, then we would have had to have a certificate of authority, but we're not a joint venture. And we would point to 489.128 that says you're not unlicensed if a business organization, in this case construction manager, has the JC. So there was the license.
Did any other bidder submit a bid? Well, we are three bidders.
Amblin University, I believe, Your Honor. Amblin University, I think that was the evidence at the hearing. One other bidder that was above us, I think bidder number 3. They submitted their bid as the Amblin University team.
I'm a little concerned, though, because it seems to me that if you're submitting a bid as joint venture, that you're holding yourself out, that this is a legal entity responsible and it's going to have responsibility to Florida A&M University. And it appears to me at the time this bid was submitted, the strike team really had no legal significance whatsoever. It was not a legally joint venture. It was not a limited partnership. It was not a corporation. What was the strike team? Tell me at the time the bid was done, was there any legal entity?
There was not, Your Honor. Strike team was the name used to refer to the entire team. The only two signatories to the bid was Urban League of Greater Miami and Construction 2. They were the only two legal entities. And our argument is they were not a joint venture.
You're
Therefore,
down to 2.5 minutes. You didn't ask for any rebuttal.
yes, please. I'd like to reserve the rest for rebuttal.
May it please the court. My name is David Self. I'm Associate General Counsel at Florida A&M University, representing the Board of Trustees of Florida A&M University. At this time, I'm joined by our Chief General Counsel, Avery McKnight, Deputy General Counsel, Shira Thomas, and Associate General Counsel Lindsey Bogan. The standard for review with respect to this case is found in Florida Statute 120.687. In order for the court to remand this case back to the university for further proceedings, the court would have to find that there had been no hearing heard on these material factual issues, and that there are no validly pending disputed facts, or that the findings of facts that was made by the administrative law judge were based upon evidence that was not competent or substantial. There was, in fact, a hearing held before the administrative law judge approximately a year ago, September 12, 2008. That hearing lasted more than an hour and a half, where counsel for the strike team admitted in several places in the transcript that the strike team was, in fact, a joint venture, and also admitted that the strike team had not fulfilled the requirements of the statutes with respect to having obtained the certificate of registration to qualify the strike team as a general contractor able to respond to the solicitation. The validity of the action depends on the validity of the university's action in its final order depends on whether these were disputed facts. The facts were not disputed. There were two facts that were fully vetted at that hearing. The first fact was whether the strike team was a joint venture or a business organization consisting of the Urban League and Construct 2 construction managers.
Okay. As part of their proposal, I'm reading from the order saying, and just correct me if I'm wrong, they said they were going to form a legal entity and would be a limited liability company, and it intends to become a joint venture. Has it been their position consistently through this litigation that now you have two individuals that were both going to be individually responsible for the bid? I guess I'm asking a question I'm going to ask you as well. I'm not sure there's a consistent position here. It seems to me, through reading through these documents, they kept on saying, well, we were going to form a legal entity, but they had not done that at the time the bid was created.
Your Honor, that would be our position, and I'd direct the court's attention to the transcript in which counsel for the strike team, when questioned by the administrative law judge, stated that, and honestly, it is a joint venture. It is a joint venture. That statement by their counsel at that hearing is found on page 24 and 25, and he states that they did not intend that they would go in without the other. So my honest response is, it is a joint venture. It is a joint venture. I'm not certain what argument they propose now to say that they're not a joint venture, having admitted it not only in those 2 pages, but in several other pages of the transcript. The university had, pursuant to the orders of the administrative law judge, invited the strike team to submit additional information with respect to this issue of standing, and they did submit a response to the university's notice of intent to dismiss this action. They provided in that response no new or additional evidence with respect to this issue of standing. The fact of the matter is, the strike team was not licensed. The strike team has formed a joint venture which itself was not licensed, as it was required by both the statute and the Florida Administrative Code.
It appears, and again I'm going to ask you, because I'm a little confused here, that at this point they're arguing that Construct 2 would be an entity that would be legally responsible under the bidding process to Florida A&M, and that's a contractor. How would you respond to that portion of their argument?
Your Honor,
it's a major part of the argument today.
Well, they have stated in their response that the strike team would be the contractor with respect to this contract. That's their response. That's not ours. And the statute says that if you're going to form this separate entity, or if you're going to do any contracting in any name other than your own, then you have to you have to comply with certain other regulations under Construction Industry Licensing Board requirements. They haven't done that, and they admitted they hadn't filed a joint venture agreement, they hadn't signed a certificate of authority, which would give Construct 2, as the licensee, the authority to do all of the contracting work on this particular
So
project.
you would concede if the petition or if the bid had been submitted by Construct 2 and that they came in 5th place and they wanted to file a bid protest, they would have standing, right?
This licensure issue would not be a problem, if that were the case. That's correct.
And a follow-up on that, I think, is the university never notified Urban League and Construct 2 before reviewing the bids that you haven't received your certificate of authority, therefore you're not a qualified joint venture, therefore we're not going to consider your bid.
That's also correct, Your Honor, but we submit that was not a requirement on the university's part. We had 6 responses to the invitation to negotiate. Several of the teams did have the licensure requirement, and a couple of them did not. The fact of the matter is we were not able to waive that requirement, even if we had chosen to do so.
So your consideration of their bid was, in essence, a nullity. Even had they won, under your argument, had they won the bid and come in 1st place, they would not be legally capable of performing the
I believe that
the duties.
I believe that to be correct, Your Honor. They would be subject to a cease and desist order by the Construction Industry Licensing Board at any time that the board would have determined that they were conducting these activities without the licensure required or the certificate of registration.
They haven't raised any kind of estoppel argument here today, right?
Well, they have used the term waiver, which I believe they probably are using that. They do use the term estoppel in a couple of places in that in their.
Do you think that is applicable?
Your Honor, actually, I do not, and I will bring to the court's attention a case that was not mentioned in the briefs, but in response to that question, a case from Coral Springs, where the city of Coral Springs specifically stated in a solicitation for the construction of a sewer treatment plant that the responders to that solicitation do not need to be licensed. 5 of those 5 people responded to that RFP. The low bidder was not licensed. There was one contractor in that group of responders that was licensed and challenged the issuance of that contract to the unlicensed bidder, and their city attorney advised that city that notwithstanding that you said you didn't have to be licensed, the law says you do have to be licensed. It's not something that the city could waive. The 2nd District Court of Appeals agreed with that. The case took a journey through the Supreme Court and came back, and they found that the city was correct and that it could not issue that contract to that unlicensed bidder, notwithstanding their statement that there was no requirement to be licensed. So in continuing, the question before the court was were these matters fully vetted at a hearing with the administrative law judge. We submit that it was. The hearing lasted more than an hour and a half. We have a 70-page transcript. We have a 100-page response from the strike team that says in several places that the strike team itself would be the contractor. The prime contractor was a term they used in one place. They said in a couple of other places they would form a legal entity, which they had not. The requirements of the Construction Industry Licensing Board are that they file a joint venture agreement, they file a certificate of authority. Those steps would have to be taken before the response to the invitation to negotiate.
Do you think, I'm going back to my question, do you think the elements of promissory estoppel are established here? Did you lead the strike team to a position in which they relied upon to their detriment?
Your Honor, we submit that the elements of promissory estoppel did not exist in this case, just as they did not exist in the Coral Springs cases found by the 2nd District Court of Appeals.
So even if you had said you don't have to have a joint venture or certificate of authority go ahead and bid, we'll review it. If you win, we'll cross that bridge when we come to it, but if you lose, we're not gonna allow you to have standing to challenge the proceeding.
Well, I'm not sure if I put it exactly.
You might not put it in quite this way.
No, I wouldn't put it that way. But, you know, even if we had said that you don't have to have these certificates, you know, the university is not the final authority with respect to the legal requirements for being able to conduct contracting activity in the state. The legislature has decided that the Construction Industry Licensing Board through the Department of Professional Regulation is the best place to handle that.
So your question is, there can never be an estoppel of law? It always has to be a factual issue?
Well, I mean, the legal question is, you know, whether the university can, whether we're even capable of waiving those requirements. And I mean, it really doesn't matter if we said it or not. And in this case, we did not. In the Coral Springs case, they specifically said it, and the city was still victorious in that case, having made an affirmative statement that no licensure was required, notwithstanding what the statute has said, and the courts came back in their favor.
Was there something about this that could have been corrected in time for the evaluation had it been? It seems to me that counsel has made a very good argument that this is real. We're hung up here on matters of form, and I understand your argument, but you know, it seems like the deficiencies could easily have been corrected in this case if they had been. It's not your responsibility to tell them, but I mean, she does make this argument of waiver in the brief, and I understand your response to the argument. But I guess what I'm saying is there anything about this that could these deficiencies have been corrected in time for you to fully evaluate the bid?
Yeah, I don't believe so because of the way they submitted the particular bid. We did have we had 6 responses. Several of those responses came from individuals who had complied, or individual companies that had complied with the requirements of licensure and certification. Some of them didn't. Some of them came in as teams. We submit that they would not be qualified also. So
but you ranked them all and evaluated them all. I mean, I guess what I'm saying is, would there be any prospect, and forgive me, I don't know that much about how this actually works, but would there have been any process for you to say, okay, bidder number 4 and bidder number 6, you don't have the right kind of paperwork here. If you want us to consider your bid, you have to send it in. I mean, is that ever done? I mean,
it could possibly have been done, but if I invite the court's attention to the way this proceeding developed. This issue of licensure was raised by a intervener in the administrative law disposition of the case. The universities, we were actually on a different track. Yeah. And it was an intervener who raised this issue, and they could still have raised that issue if we had asked, you know, the people who had this paperwork.
Your point, I guess, on that one is that they certainly had standing to complain about this, whether the university
that's correct.
Gave up some point or not.
That's correct, because their position, and the university has adopted that position, is that the licensure is in fact required, notwithstanding the silence of the ITN on that particular matter. So I'll just get back quickly to summarize. What the statute 120.68 requires, if the court intends to remand, is that it find that there was no hearing held and that there were factual disputes still at issue in this case, or that those issues were not raised, or the facts findings were not reached based upon competent substantial evidence. We submit that given the hour-and-a-half long hearing, the transcript, the submittals by the strike team, that the requirements of the statute have been fulfilled, and we would ask for judgment in our favor. Thank you.
want you to address this. It's part of my MO. People walk to the podium, I ask them a question while they're walking. I want you to address this, though. It seems to me there was language in your bid and in your petition that at least implied that this was going to be a joint venture or a limited liability company. And now you seem to be arguing that this contractor would have been on the hook directly to Florida A&M University. Are those positions consistent, and am I wrong about the position that was being taken below?
With respect to the position you just stated, Your Honor, in fact, we did state in the proposal that they would form an entity. But I think the proposal or the bid did not require the individual or the entity that was submitting the bid to form this legal entity. That was not required.
What's the whole purpose behind the saying that, the rules and the statutes dealing with when you're a joint venture to actually have the joint venture agreement in place when someone bids?
When someone is awarded the contract, yes, Your Honor. This was an invitation to negotiate, and it was done on a team approach. The two individuals that signed the bid were Construction and Urban League.
But FAMU points out in its brief that negotiating is itself contracting under the law.
Correct, Your Honor.
So you would have to have the contractor's license to do the negotiating, if I understand their argument.
And we did. One of the entities did have that, and that's undisputed. They had the JC. My position is that it didn't have to be this one joint venture, as they call it, to have the license. And even though we did refer to the strike team as the prime contractor, throughout the proposal, there was reference.
Tell me on bidding law, though. My understanding of bidding law is when you submit a bid, that is an actual offer that the governmental entity can accept into a binding contract with the person that submitted the bid. How could they do that if the entity that they were going to contract with didn't exist at that time?
This was a proposal, and it was an initial stage. It wasn't that they were accepting the bid. What would happen was that you would be ranked, and then the award would be done later on.
It's a little different than a bid. Okay, I'm sorry. Go ahead.
Well, Your Honor, what I'm trying to say is that, in fact, if they accepted the bid, the university still had to approve it and make sure it met all the technical requirements. That's in the proposal. This was just the initial stage.
When you submit this, the university has the right to accept the proposal.
Correct. They did have the right. They did have the right, and they could also reject it. I think it's important.
Which would have some legal responsibility on the other entity. But if the other entity doesn't exist at that point, how can there be legal responsibility on the other side?
Because the entities that submitted it did have legal responsibility and did exist. They were legal entities. They were two individual legal entities here, and they both had the responsibilities because they both signed the contract. Now, with regard to the waiver argument that Judge Thomas made.
Okay, I'll give you about 30 seconds.
Well, then very quickly, I do think there's an issue of waiver here, especially since the committee, the evaluating committee, pursuant to the proposal, found that we met all the state and legal requirements, and that was the university's position when they ranked us.
Okay,
that's in the proposal.
Okay, well, I'm controlling the clock, so I'm going to ask you one other question. They make the argument that another bidder or another person that makes proposals can challenge the qualifications of a competitor.
Mm-hmm.
And I believe that's right. So respond to that argument. How can the university unilaterally waive the requirements for a qualified bidder?
Well, number one, because they already did when they ranked us, and all we're trying to do is say on the merits. Now, with respect to the intervener, I know.
But legally, how can they?
Well, because that's all that the proposal required, Your Honor. If later on the contract is awarded, then they could do that. But very quickly, Your Honor, if we accept the university's argument, then in effect, nobody could ever challenge the process. All they would have to do is accept the person as responsive and later on down say, oh, it's unqualified. And that's not the standard. The standard is, do they have a potential stake in the outcome? And they do. Regardless if you want to accept the argument that they weren't licensed, which we don't concede at all, they still had a stake in the outcome, and they're entitled to, at the very least, to proceed on the hearing, because that's all that is necessary.
I have one. I want to clarify again. Urban League was not licensed and could not have a stake. Is that not true?
No, Urban League did have a stake because they were the developer, and developing was required by the proposal. So, yes, in fact, they have a stake. This is not just the construction of a building. They had to be developed. So they had a stake as a developer. And most of the companies...
Urban League Incorporated as a developer?
Urban League submitted as the developer of this project, and and just very, very quickly, Your Honor, two of the bidders that were put ahead of us were entities, were joint ventures, and they were allowed to proceed. So it seems that if we follow this to the legal conclusion, then no one can ever be a bidder. You can never challenge the process. In other words, the statute is gutted. All they have to do is after the fact, after they said we met all the state requirements, to say, oh, you didn't, now you're no longer a bidder. Thank you, Your Honor. We would ask for remand for further proceedings. Thank you.